Have you ever wondered how something can be legal in one state and illegal in another? Or why something like the recreational use of weed is legal in 21 states, but still illegal at the federal level? Well, it's all because of states' rights, the powers that are governed by individual states instead of by the federal government. But which rights belong to who and why?
Hey, go home! Abortion bans have got to go!
As we know, the United States has a constitution, which are the laws that govern the whole country. But every state and territory in the US also has its own constitution. To understand why that is, we have to go back to when we were under the Articles of Confederation. Back then, each state had its own military, post stamps, treaties, and currency. Basically, each one sort of acted like its own little country. Of course, at the time, there were only 13 states. But still, the framers found that 13 independent states made the US pretty hard to manage. So, in 1787, there was a meeting in Philadelphia to figure out a solution. It was decided at that now famous Philadelphia Convention to create the United States Constitution.
13 states bound into a firm union, a union founded on the rule of written laws.
But the framers knew they didn't want to end up creating the same kind of system they had just fought to free themselves from. They didn't want states to be ruled by some sort of king. So, in 1791, the 10th Amendment of the Constitution was ratified, officially establishing states' rights by saying that any powers not delegated to the federal government belong to the states and the people. Under this doctrine, state governments can control things like driver's licenses, marriages, buying and selling real estate, education, state highways, and collecting state taxes. And the federal government controls national things like the military, printing money, immigration, and protecting the entire country. This system, where people are governed by both state and federal governments, is called federalism. The big question when it comes to federalism, though, is what happens when a state and the federal government don't see eye to eye? Under Article 6 of the Constitution, what's called the Supremacy Clause, the federal government's laws override the states. But if a state refuses to oblige, they can battle it out in court. We saw this in 1954, when some states forced white children and black children to go to separate schools, even though the federal government deemed it illegal.
Segregation now, segregation tomorrow, and segregation forever.
They fought it out in what's now the famous Supreme Court case of Brown versus Board of Education.
We do believe that this decision in itself will encourage the people to take further steps without litigation in many areas.
Throughout history, many progressives have been skeptical of federalism because in many instances, states' rights have been used as a way to resist civil rights. But federalism has also been used by lawmakers in democratic states to resist conservative policies too. When the Patriot Act was put into law after 9/11 to help protect the US from terrorist attacks through increased surveillance, some states didn't just denounce the Patriot Act's broad surveillance and detention rules as an attack on civil liberties. They actively resisted it. States have also resisted national education reform. During the Bush administration, many states resisted the No Child Left Behind Act, which increased the federal government's role in holding schools accountable for student performances.
We're asking states to design accountability systems.
These states manipulated testing standards and dragged their feet when it came to implementing the reforms. In fact, they were so stubborn that the Bush administration eventually gave up and granted states so many waivers that the program was essentially gutted. Today, states' rights are at the forefront of some of our most crucial legislative issues. For instance, while many states have enacted laws legalizing recreational marijuana use, the possession and sale of marijuana continues to be a violation of federal drug laws. Even though the Constitution establishes that national law trumps state law, the 10th Amendment provides an exception when it comes to the use of police powers. So basically, states can't prevent federal prosecutions of their citizens who are using marijuana. But by making such use non-criminal under their own laws, they can eliminate state prosecutions of those citizens under state law. When it comes to issues like gun violence and the death penalty, state laws are where we are seeing the most regulations being enacted. Whenever Congress or the White House doesn't establish a national policy, it's up to states to decide the rules.
Our rights are not up for debate.
We saw this with the overturning of Roe v. Wade, the Supreme Court decision that made abortion a constitutional right. Without Roe ensuring the right to abortion across the country, states that wanted abortion to be illegal have been able to make it so. Others have used the Supreme Court's 2022 decision to explicitly make abortion legal.
Abortion rights rise up!
Clearly, there are a lot of issues that individual states and the federal government don't agree on. And some of those differences can be really consequential. That's why it's so crucial to not just vote at the federal level, but at the local one too. Because it's those local officials, like your governor and state legislators, who make these decisions and have the biggest impact on our day-to-day lives.